Hi all, thanks for joining us. This is Laura Danielson, and we have a large group today this Halloween, so button up your overcoats and prepare to be scared. Seriously, we are facing some difficult immigration challenges together, so what better day could there be for this? As always, our goal is for you to be prepared and armed with knowledge and information that's going to assist you and your employees in navigating what has become for many a very difficult and often lengthy immigration journey. So let's plunge right in. Well, actually, this is not plunging right in, but these are beautiful pictures of us without costume. You should see us now. The travel ban. Is there a travel ban or not? And if so, does it impact you or your employees? So, last January, as you probably remember, President Trump initiated a travel ban against nearly all people from certain Muslim countries, including lawful immigrants, those with work visas, and refugees. An outcry arose. Our airports became places of protest and assistance. Lawsuits were filed, and quite quickly the ban was ruled unconstitutional by a number of courts, mostly on religious grounds. Then, on March 6th, a new ban was announced, which was mostly an attempt to cure the ills of the previous ban. And I would call this sort of the travel ban light, in which only 6 of the 7 previous countries were included, and it spared Iraq. The time period was limited, and the permanent ban against Syrian refugees was lifted. Certain immigrants were also spared, such as those with green cards or visas. Within weeks, this new ban was successfully challenged in different federal courts, and the ban was blocked from implementation. President Trump tweeted that this was a watered-down version, and he should have gone with the first one anyway. The Supreme Court in June allowed partial implementation of the second ban while it considered the case and allowed for entry by those with a bona fide relationship with a person or entity in the United States. This ban did take effect on June 29th, and the Supreme Court was slated to hear arguments on it earlier this month in October. So then, fast forward to September. In late September, a new ban was announced that was supposed to take effect on October 18th. This ban had an indefinite time period. It added Chad. It added North Korea, which almost never allows its citizens to travel, particularly to the United States. And it added a very limited number of mostly government officials from Venezuela. And this was, in my opinion, an attempt to show that it wasn't only a Muslim ban. This ban also took off Sudan. Now, 2 federal judges have already found this latest ban to be unconstitutional. One cited the president's own words about it being a Muslim ban, and the other stated that the president had exceeded his authority. Meanwhile, the Supreme Court stopped examining the second ban, which had become moot. So people from these banned countries under the third ban, can these people from the banned countries under the third ban enter the U.S.? Well, yes, theoretically, for everyone except those from North Korea and Venezuela. But in our experience, it has been extremely difficult for such people to be approved for visas. And we'll discuss that a little bit later. As far as the ban goes, all we can do is stay tuned for further developments. So next we're going to talk about the 90-day rule. And the 90-day rule replaces what has been referred to as the old 30/60-day rule. And that rule is really not a law, but it's a rule in the USCIS policy manual, which says that if someone enters the U.S. on one kind of status, such as a tourist status, and then does something to contradict that status, such as file a permanent residence application, that person may have entered the U.S. with fraudulent intent, unless this action occurred more than 60 days after entry. And there's a few nuances regarding 30 and 60 days that I'm just not going to get into. But that was the rule that has been in the USCIS manual, and it's actually still in the manual. But the Department of State has amended the Foreign Affairs Manual to create a rebuttable presumption of fraud or misrepresentation if any inconsistent conduct occurs within 90 days. So the definition of inconsistent conduct has been clarified in the manual, and it has been expanded to include things like taking unauthorized employment, enrolling in school without the proper visa, engaging in marriage to a U.S. citizen that has residence in the United States, or taking residence in the United States with that person, and undertaking any other activity for which a change of status would be required. For example, entering as a tourist and applying right away for student status. And there's so many others that we can think of. Now, while USCIS hasn't yet implemented these changes in writing, we are, of course, concerned and cautious that it may find fraud for anyone who has taken steps to apply for permanent residence after entering on a temporary status. So, as we know, H&L visa holders are protected statutorily. So we aren't as concerned about them. But what about those people on TNs or O1s or F1s or E visas and any other unprotected visa type? While the finding of fraud might be rebutted with good facts to the contrary, it's a really harsh finding. And a finding of fraud has a consequence of being barred permanently from the U.S. So therefore, we are advising extreme caution, and that clients that are entering on temporary status wait for at least 90 days before taking any permanent steps. And what that really means is that they enter the United States and wait for 3 months before perhaps filing for lawful permanent residence or anything else. So it essentially grounds them. There's a travel restriction for that period of time. So next, I'm going to talk about advanced parole. So advanced, let's just first of all just discuss what is advanced parole for a second. When someone files an application to adjust status to lawful permanent residence in the United States, technically departing the U.S. terminates that application, which is why we apply for advanced parole for people, which is essentially permission to re-enter the U.S. in order to allow for the adjudication of the adjustment of status application. And since it's now taking 90 days or longer to obtain that advanced parole, we don't recommend travel outside the U.S. without it. Now, I'm old enough to remember, just for a little bit of perspective, that we used to be able to get advanced paroles pretty much the same day that we filed permanent residence applications. So 90 days is a long time for people to wait. Now, what do you do about people that have H or L status on advanced parole? Because there's a recognition that a lot of people who are H or L employees are traveling. They need to travel for business. And so for years, there's been an exception that those that have H or L status, they're allowed to travel internationally without consequences so long as they have valid visas to re-enter on, if they are required to have such visas. So the USCIS has permitted them to travel internationally and then has gone forward with the adjudication of their adjustment of status applications and has gone forward with the adjudication of these advanced parole applications. So, for example, if they travel within that 90-day period, they are still going to have those applications approved and they enter in on the HRL status. Now, however, there's been a reversal of this long-standing practice with the USCIS considering the advanced parole application as being abandoned if the travel abroad occurs prior to its being issued. And this affects both initial applications and renewals. And we are even seeing denials of renewals where a person is traveling back on an existing advanced parole but has filed for the renewal because of the knowledge that it takes so long to get. Fortunately, we haven't seen denials of the adjustment of status applications, but in our opinion, that would still, of course, happen if someone travels without an H or L, such as an O or an E, without an advanced parole approval. So the consequences are that really people should not travel with the advanced parole application pending, which is going to be 90 days or longer. For H or L visa holders who absolutely must travel for emergencies or business purposes, it should still be possible to still submit a new advanced parole application on their reentry. But if you combine the fact that there's the 90-day fraud ruling that I talked about previously with this advanced parole ruling, a lot of people are going to essentially be grounded in the U.S. for 6 months. Now, the last thing that I'm going to speak about is extreme vetting and consular delays. In early June, President Trump tweeted in response to various objections to his travel bans the following comment. Well, in any case, we are extreme vetting people coming to the U.S. in order to help keep our country safe. The courts are slow and political. And I can say we are definitely seeing the consequences of this extreme vetting in all sorts of adjudications. First is this new form DS 5535. And this is a new form that's been developed for the purpose of resolving, for the stated purpose of resolving identity issues or vet for terrorism. And we've seen clients that have received this new form, and the questions are extremely detailed. For example, they ask for 15 years of travel history, employment history of 15 years, identities of extended family members, social media platforms and identifiers, and phone numbers and email addresses going back in time. So in preparation for this, people, especially those who might be impacted or think they might be impacted, perhaps coming from some of the countries that have been focused on in the past, should keep meticulous records. A simple error could result in a finding of fraud. So far, my personal experience with this form is with an Iranian artist that has traveled back and forth to the U.S. many times, and after completing the form was placed in a long administrative review. And even though his case was initially approved last year, he and his family have still been unable to enter despite the lifting of the bans. Next is the new process of requiring visa interviews for everyone. In early March, the president ordered that all applicants to the U.S. must be scrutinized more closely than ever before entry to the U.S. And I don't mean everyone, including people with visa waivers, but anyone that's required to get a visa must attend a mandatory interview at consulates abroad, and that includes visa renewals. So previously, especially in really busy posts, people getting visa renewals have been able to drop their passports off and pick them up later with new visa stamps. This has and will, this new policy will continue to increase backlogs at consular posts and can result in months-long delays for those flagged for additional investigation. The consequences for individuals needing to travel on business who also need visa renewals are significant, since consular delays could result in their absences for far longer than desired. So it's another factor that has to be considered by companies and their employees before sending people out to travel. And finally is the fact that there are now mandatory green card interviews as part of this extreme vetting policy, that all applicants for green cards in the U.S. must now be interviewed for, and that includes those seeking adjustment of status based on employment, which for years have been adjudicated by the service centers without interviews. Now, this took effect on October 1st and will likely result in further backlogs and delays at our local offices, and Lon is going to be discussing this further. And so now I turn to Lon for her presentation.
Thank you, Laura. Good afternoon, everyone. So before I start, I just want to frame the discussion that I'm going to have in regards to I'm sorry, I just realized that for some reason the microphone was not on. So before I start to discuss the current situation in regards to the adjudication of employment-based immigration petitions and other trends that we are seeing, I just want to remind everyone that we have had no legislative changes since President Trump was became president, and everything that we're discussing right now has been based on policy changes or changes in regards to adjudication internally within the administration. And it's amazing that despite the lack of legislative action by Congress, how we have seen tremendous changes within the USCIS and other departments within the Department of Homeland Security since President Trump has come into office. First, before I go discuss some of the changes that we're seeing and trends, I want to address and frame the current turmoil that we are facing with employment-based petitions. It's been a very busy 6 months for employment-based immigration attorneys in light of some of the decisions that we are seeing. And I think this also applies to employers who are seeing a increase in work, not only by their foreign national workers in obtaining information, but also their HR staff and legal staff in order to respond to some of the trends and changes that we are seeing at the Immigration Service. So to understand the current turmoil in employment-based adjudication, I want to first go back to what occurred on March 31st and in April. March 31st was the date that the Trump administration issued a statement saying that it would be no longer relying on a guidance memo that was issued in 2000 regarding the adjudication of computer-related H-1B petitions. Essentially, what it stated was that the guidance that the Immigration Service has been following since 2000 would no longer apply to any H-1B petitions that would be filed after April 1st, which was the start of the filing season for fiscal year 2018 H-1B petitions. Then on April 3rd, the Trump administration announced measures to detect H-1B visa fraud and abuse. And also the day after, it announced plans to protect U.S. workers from H-1B discrimination. Then came the announcement by President Trump of Buy American and Hire American. So in essence, that is the context in which we are currently operating under for non-immigrant petitions filed by employers to hire foreign national workers. It's been a little bit, almost 6 months after that first announcement in March and April, and the trends and the policy changes in USCIS adjudications for H-1B petitions specifically, but other non-immigrant work visa petitions have been very impactful, and it has completely changed our practice in regards to the filing of non-immigrant work visa petitions. First, we've seen a 46% increase in the issuance of requests for evidence, specifically mostly for H-1B petitions filed after April 1st. We have also seen various requests for evidence that we've never seen before. We have seen requests for evidence for petitions filed where the Immigration Service would request more information from employers as to whether a position is a specialty occupation for H-1B filings. However, it's very interesting that many of the RFEs that we are seeing right now not only covers positions that may be questionable in the past, but they are also questioning whether positions such as a physician or engineer or teachers meet the definition of specialty occupation. For those of you who are familiar with H-1B petitions, in order to qualify for a H-1B petition or status in the United States, the employer must establish that the offered position requires a bachelor's degree in a specific field of study or related specialties. And what the Immigration Service is stating now is that its interpretation of the definition of specialty occupation is that the position must require a field of study in a specific field of study, and not just where there are occupations that will accept a variety of fields of studies or specialties. It will question whether that is indeed a specialty occupation. So we have been dealing with a lot of RFEs in regards to the definition of specialty occupation and whether certain occupations that we have traditionally viewed as specialty occupations are now being required, and actually occupations that are outlined in the USCIS regulations are being questioned as to whether it meets the definition of specialty occupations, such as engineers. Other types of RFEs or requests for evidence that we are also seeing relate to whether the employer has filed a proper labor condition application for the offered position, because the Immigration Service believes that the position includes duties that may require a higher wage rate than the one that was filed on the labor condition application. So we call these the level 1 wage RFEs, and we have seen a slew of these RFEs. We've never seen these RFEs prior to the current administration, and it's what has happened now is that it's really caused us to change our practices. The law is the same, but we are now addressing decisions by the Immigration Service that is really not based on any legal analysis or regulations, and the determinations that they're making are very arbitrary. For example, a decision by the Immigration Service to deny a H-1B petition because they believe that the employer should have offered a higher wage level than that offered on the LCA would state that the USCIS believes that the offered position include duties that appear to be advanced, and thus a level 1 wage would not be the appropriate wage for the position. So as you can see, we are now dealing with having to address decisions that are not really based on legal analysis or the regulations either. And what that means is for employers, you're going to have to work a lot more with your attorneys to prepare petitions that include more details about duties, why you pay the wage you pay, and make clear that we have evidence in regards to the various wage levels that the company may have for the position. So in addition to the RFEs that we're seeing, we also recently received communication from the administration that it would no longer defer or give deference to prior decisions in non-immigrant petitions. So for example, if you've obtained a H-1B petition for someone who is an engineer, you can't take it for granted that you're going to be approved when you extend that individual status. Just recently on October 23rd, the memo was issued that stated that all USCIS adjudicators now must look at each petition individually and place the same type of scrutiny that it would for an initial petition. So essentially, it has now reversed its policy of giving deference to prior decision. Ironically, the regulations state that for extensions, the Immigration Service should follow its prior decision unless there's been material changes, and employers are not required to give the same amount of evidence as initial petitions. But in this memo, the current administration is completely ignoring that policy. As Laura mentioned, other trends that we are seeing is in USCIS interviews, where employment-based applications where an individual has an I-45 adjustment of status application based on I-140 employment-based petition, they will require in-person interviews at the local USCIS office. This will apply to any applications filed after March 6, 2017. And the Trump administration has stated that this policy change is to ensure that it protects the U.S. against any foreign terrorist entry. So that means that there will be a longer waiting period for approvals on I-485 applications. Family-based petitions will be put behind the line of employment-based petitions. And we will definitely see other trends and policy changes that will relate to this Buy American, Hire American policy that is now really the thread throughout any policy changes and memos that are coming out of the Trump administration. So I'm going to also talk about worksite enforcement, because we've heard a lot about the border and the wall, but I think it's really also important for employers to be reminded of the fact that part of Buy American, Hire American is also to ensure that employers are hiring U.S. workers. And under the current administration, that means that it will be focusing on worksite enforcement. For a little while, the Trump administration has been quiet on this issue. We've seen I-9 audits continue to be conducted by Immigration and Customs Enforcement, but about 2 weeks ago, I believe it was October 16, ICE Director Holman made an announcement that the Immigration Customs Enforcement Agency that he heads, ICE, is preparing to quadruple worksite enforcement actions in 2018. Now, what was interesting was during his statement, he was very clear that not only would the ICE be going after employees that it discovered during audits that it wouldn't turn a blind eye to the fact that these individuals were not authorized to work, but it would also go after employers who it believes had knowingly engage in activities where the employer was employing undocumented individuals. So it wasn't just an announcement of worksite enforcement and audits, but a clear warning to employers that they may face not only civil penalties but criminal consequences if they engage in knowingly hiring individuals who do not have work authorization in the U.S. And so what we see here is perhaps a combination of the Obama administration's focus on I-9 audits, but also, in addition to that, the Bush administration focus on worksite raids. And that's what we definitely will be seeing in the future, further actions perhaps from the administration to encourage Congress to pass a mandatory E-Verify law. Right now, Representative Lamar Smith of Texas has proposed legislation basically that would mandate the use of E-Verify by all employers, and that is, we're still waiting to see what happens with that, but that's something that the Trump administration is definitely encouraging. In line with Buy American and Hire American is the increase of fraud detection and national security investigations, and also the increase in audits by the Department of Labor and USCIS. We have definitely seen an increase in wage and hour investigations. This is in line with the focus on detecting H-1B fraud and abuse. And in recent meetings with the Wage and Hour Division, they are getting ready to increase their staff to make sure that they can comply with the policy and the goal of detecting H-1B fraud and abuse. So what does this mean for employers? It means that you need to start making sure that your labor condition application files, LCA public access files, are in order for those who file H-1B petitions. And it means that if you have not conducted an internal audit or have had a third party such as an attorney audit your I-9s in recent years, it is now time to make sure that you get those files in order. We have seen warnings from this current administration regarding its focus on employment-based petitions, and as a result of that, the consequences of RFEs we've seen in the last couple of months have been very detrimental to foreign national employees and to employers. So we expect that the next line of defense that we're really going to have to focus on are the I-9 audits, and focusing on helping employers ensure that they have the proper documents to protect themselves against audits, because this administration has clearly announced, and their actions clearly show that they're going to focus on making sure that U.S. workers are protected. Unfortunately, the actions that are taking place right now are not in line with the current regulations we have. And we definitely will see a focus also on investigations of U.S. employers in regards to potential discrimination of U.S. workers as a result of hiring foreign national workers. There's been a slew of decisions by the Department of Justice Immigrant and Employer Rights Section, formerly known as the Office of Special Counsel, focusing on cases where employers have been found to discriminate against U.S. workers through the hiring of H-2B or H-2A workers. So it's been a very difficult time for U.S. employers who file non-immigrant visa petitions with some of the decisions we're seeing. And I can tell you, in talking to colleagues among the immigration bar, this has been the most difficult 6 months that we've had, and we don't expect it to change in the future. But we're still hoping that there may be light in the tunnel for others, and I'm going to turn it over to Deborah to talk about our dreamers and perhaps what they may face in the future.
Thank you, Lon. I only wish I was here to talk about positive information. So what is deferred action? Well, in June of 2012, President Obama was one of the first presidents to step in to address the dreamer issue that was facing our nation. The question is, what should our government do with the nearly 1 million undocumented students who came here as children, who have gone to our schools, some have served in our military, and want to come out of the shadows and contribute to our society? Congress has failed for decades to pass legislation to provide a path to citizenship for these worthy children. So through executive action, President Obama created the DACA program to provide a temporary basis to prevent their deportation, allow them to legally join society by providing them with work authorization, and provide a means through advanced parole to allow them to travel and return to the United States. DACA was for all purposes a success. It provided temporary work authorization and stopped the deportation of nearly 800,000 kids who had lived in the United States. This temporary measure was limited to those that met certain criteria. You needed to be under 31 in June of 2012, have entered when you were still a child, be physically in the United States as the date DACA was created, have gone to school, graduated, or honorably served in our U.S. military. You couldn't be a criminal, and if you met these criteria and could prove these factors, you would be blessed with work authorization and the ability to travel and avoid deportation. This was still supposed to be a temporary measure. The hope was Congress would pass legislation to actually provide a long-term path for citizenship for these children. When Trump was running for office, he promised that he would do something to help DACA students and had told them they would be safe. However, in September of this year, the temporary protection ran out. President Trump rescinded DACA. His basis alleged that this would be an impetus to Congress to finally act and pass legislation within the next 6 months. To date, there have been 5 bills proposed, but nothing has progressed. Not unusual for Congress, but this means that DACA beneficiaries are running out of time. As an employer, you may find out that many of your workers, when their I-9 needs to be updated, will no longer be able to provide you with evidence of their ability to work in the United States. Many college students will be forced to leave their studies, and others will be at risk of deportation. So what do you do? Well, encourage Congress to pass legislation by March of 2018 to protect and provide a future for these hardworking young adults. There are many businesses who have joined with the U.S. Chamber of Commerce to support a group called the Coalition for the American Dream, including companies such as Best Buy, Google, IKEA. If you're interested in joining this effort, you can go to www.coalitionfortheamericandream.us. So I encourage, if this is something of importance to your business, to your workers, or even maybe your children's friends at school or college, to take action if possible. So I'm also going to talk about the RAISE Act, which is a proposed legislation that was introduced by Senator Tom Cotton and Senator David Perdue and supported by President Trump. While this may not likely become law, it's important because it provides a framework of where we see this administration heading in its belief on where legal immigration in America should go. The RAISE Act essentially creates a point system to determine who will qualify for employment-based green cards in the U.S. and who will qualify for family-based green cards in the United States as well. Its premise is to award those who are young, who are English-speaking, and who are highly educated. So who does it harm? It harms families. It cuts down on the number of legal immigrants allowed in the U.S., and it makes it more difficult for talented older Americans to immigrate to the United States. It also eliminates the diversity visa lottery, and also restricts humanitarian grounds in terms of refugee numbers to only 50,000. For family-based immigration, it would prevent U.S. citizens from bringing over their parents to the United States, from sponsoring adult children or siblings. This is a huge change for the American immigration law system, as our immigration law has focused on family unity, on allowing families to stay together and bring each other over through our legal process. What this new act would do is curtail that tremendously. It would separate families. It would still will not solve the long waits that many are facing, and it's going to arbitrarily decide who will stay in the U.S., really looking for those with extraordinary accomplishments, not those who are actually benefiting business in the United States. So what does the future look like? So it is kind of haunting, which is the reason we're doing this on Halloween. But in terms of our immigration system, there are future risks that we should be aware of and make sure that we're speaking up about. So as everyone has heard in the news, NAFTA is under negotiation or renegotiation, and with that, which means TNs could be at risk. TNs are used by most individuals coming from Canada and Mexico who work in a specific specialty occupation as listed in NAFTA. It's an excellent means for finding qualified workers, and it could be negotiated out of these discussions. Keep in mind that anything we restrict could also likewise be restricted abroad, which means it could be more difficult to send your U.S. employees to work in Canada or Mexico as well. As Lon had discussed the many, many H-1B challenges we have faced, but it's also relevant to discuss the cap exemption issue that has come up, where the agency has created regulations defining what employers qualify as cap exempt from the H-1B cap. And with this has also not given any deference to those who have been cap exempt for well over a decade, and has required much more substantial documentation than ever before in making one cap exempt. So this impacts universities, nonprofits, and affiliates associated with these universities as well. L1s, we are seeing agency challenges to prior memos in defining specialized knowledge. We're seeing also an increase in requests for evidence. And we're also seeing challenges to new businesses being founded in the U.S. where they're looking at funding sources which has never been requested in the past. On humanitarian level, Trump has issued only 45,000 refugee numbers this year, which is the lowest number in a decade. We also note for F1 students, this increased vetting that Laura discussed means we may have a smaller pool of foreign nationals coming to the United States, which means you have a smaller workforce of STEM qualified graduates, which means we're going to see in the future a lower number of H-1B applicants and qualified workers. And to keep in mind, if they're not coming here, they're going elsewhere. It's not as if these bright young students aren't going to continue to study in their field, but they're likely going to be working in Europe or Canada or Australia. This also could impact the visa denials. Administrative processing creates a culture of fear. It could decrease our tourism, and it's going to make our lives more complicated, ensuring protections of our workers and our foreign nationals. Laura, after all this great, exciting news about our immigration process, how can we remain positive and continue to use our immigration system to maintain our talented workforce, fill labor shortages for temporary needs, and meet the hiring needs of companies looking for professionals in our global world?
What a question. I guess my first part of answering this is that I really have to believe this is only a moment in time. Things ebb and flow historically, and who knows? Based on yesterday's news, it may end sooner than we think. But I'm sorry if this sounds political to those of you listening, but we are immigration advocates, and so whether it's political or not, we believe in immigration and immigrants, and really have to hope that we're still people who consider ourselves to be a nation of immigrants. I also think we have to fundamentally believe that our system has checks and balances, and that if things aren't working, if too much power is being amassed on the administrative side, that challenges have to be made in courts. I'm currently, I was asked to write an article for a new edition of the Hennepin County Lawyer magazine on how we can stay buoyed at times like this of difficult change. And I know that many of you listening are facing these same challenges with your own workforce or your family members or whatever. It is hard, very hard to stay optimistic. And so I've given this a lot of thought. And honestly, what we talk about among ourselves is that we take encouragement from our own clients who often remain resilient through tremendous challenges, long waits, terrible things that have happened to them in their home countries before they became refugees, if they are refugees, or even just long waits that people have had to undergo, you know, through their employment process. And you know, a lot of folks don't even realize this, but there's people in the United States who are working for companies who've never violated immigration laws, who've done everything right, who are waiting to get their green cards, and they've been waiting for, you know, maybe a decade or 2 decades, and they are they're worried that they might lose this status that they're in at any moment, and they really have oftentimes had to forego things like going home to visit family members, attend weddings, attend funerals for their own parents. It's been a really sobering thing to witness, but the resilience that we see among these people is what gives us heart. And we also have to remember that we are lawyers. You know, we are employers, for those of you who are listening, and we really need to persist and combine hope with action. I think that companies today have to consider not only lobbying congressional representatives, but actually suing to get the laws addressed. Congress enacted laws that have backup regulations, and we're now seeing a situation where they are not being regarded or respected. And this is something that we really would like to ask our employers to consider if they have good cases. We have lawyers who would be willing to do this without charge to not just, I'm not saying within our firm necessarily, but I know a number of colleagues that are really, really willing to do this and work with us on this, because we really need to challenge and push back on what's been happening. So I guess that leads us to questions.
I believe there is a chat function, so you may please type in any questions that you have, and they will be directed to us, and we are happy to answer them. Anything related to our topic or immigration, we're here to answer. And while we wait for questions to come in, Lon, I have a question for you. In terms of the compliance, if you could provide just 2 steps, what can employers do right now as part of risk management?
2 steps. Review all your audit files for labor condition applications or perm filings. Those are any filings that you have in regards to the sponsorship of foreign national workers in H-1B status. Make sure that your audit files contain all the requirements. For our cases and for our clients' cases, we provide a checklist of all the various documents that should be in a labor condition application public access file. So it's really important for you as an employer to review that checklist and make sure it's updated and it contains all of the documentation laid out in the checklist. Number 2, I-9 compliance. If you have not conducted an internal I-9 audit, of your I-9 files, it needs to be done immediately or as soon as possible. And in conducting a self-audit or an internal audit, I want to caution employers to make sure that you have individuals who are well-trained or get the assistance of an attorney who works with I-9 compliance. Not all attorneys have experience with I-9 compliance, and it's really important that you work with someone who has that experience. And it defeats the purpose if you have individuals audit I-9s if they're the ones that are responsible for completing the I-9s internally. So try to make sure that you have, as I stated, a third party conduct the I-9 audit, or someone who does not complete those I-9s day to day, because it's going to be difficult for them to catch the mistakes that they make.
So I have a question here that is from an HR manager wondering how to anticipate all these changes when hiring a brand new foreign national employee. And I guess I would answer by saying that it's more important than ever to start early and to have a strategic plan to follow. So rather than just applying for the standard visas and not really thinking much further out than that, the work that we do now more than ever should include a short-term strategy combined with a long-term strategy. And sometimes we have to be willing to consider options or changes in that strategy. For example, as we've seen Indian nationals get further and further backlogged in their second preference applications, it might be worth considering other options. I know that many clients are. We're seeing individual Indian nationals that are applying for investment-based immigration, which is current right now for Indian nationals under fifth preference, EB5, even though they have every intention of remaining with their employers. They just don't want to wait another 10, 15 years, especially with the concern about the possible denials. So that's what I would answer. Do you have any thoughts, or you got another question there?
Yeah, Deborah, you're gonna. We received a question regarding the backlog of cases and whether you would recommend to spend the extra money to pay for expedite fees. I presume this is in regards to premium processing.
Correct. And so premium processing is not available for all steps of immigration. For most non-immigrant petitions, it is available for employment-based sponsorship. Whether we recommend it, I look at it this way. Your employees are anxious and nervous, and with the increase of RFEs, many of them want to have some certainty in knowing it's approved. It pending for over 6 months, we even saw H's taking as long as 9 months, can impact their ability to travel, to bring over family members. And so often it is worth the investment to have certainty in the process. Also for potentially I-140 petitions, unless you're a multinational manager or a national interest waiver, premium processing is available. And that's actually a pretty, 15 days you get a decision and you have your place secured in the immigration line is very much worth it to many individuals. You cannot premium process adjustment of status. We can't alter the backlogs that certain nationals face based on their country of origin where they're at in immigration line. They're just subject to the wait. But I would say well in the majority of our employers do premium process when it's available for them.
And I just wanted to add to that I've heard people suggest a rumor that there is a rumor out there that if someone premium processes an application, especially in the permanent categories, that will increase the likelihood of a request for evidence or a denial because the officers are, required to respond within 15 days and maybe aren't going to turn things around quickly enough to review carefully, and that they'll just just send back a boilerplate RFE. And I just wanted to say that I don't think that has been our experience. Sometimes we get boilerplate RFEs, but not because of premium processing. So what, you guys are both shaking your head.
Yeah, I think I agree with that in regards to, I think the rumor was really focused on the EB1 petitions for individuals of extraordinary ability, because those cases are so voluminous, and so they want additional time to review the petition. But at this time, where it gives peace of mind to our clients, employees and employers, I think it's really smart to take advantage of premium processing. Another advantage of premium processing is that if there are issues with the case, we can email the premium processing unit to get issues resolved instead of going through the standard process. And so there still are advantages to it, and we're really glad that they've brought it back for H-1B filings, because that was very difficult when it went away for a while.
Even though I do call it a bribery fee, because it's, you're basically paying extra money to have the government do their job faster, but it does have an advantage.
So another question we received was, do you have any predictions or updates on TPS for Haiti that was extended to January 22nd, 2018? At this time, I don't have any different perspective, except what the administration stated was that they extended it up until January 22nd, 2018 in order for individuals to get their lives in order and to get ready to leave. So unless there is some type of heavy lobbying that's taking place right now, we don't see any changes. Usually with TPS, you don't have that type of warning that you need to get your life in order to leave. And so unfortunately, at this time, I don't have any different perspective. I don't know if Deborah or Laura, you have.
So, well, Lon, here's a related TPS question, just in general. If TPS is terminated, what's the next step for employers?
That's a really good question, and something to consider for individuals who are on TPS status. If you have not sponsored them for H-1B status, it's something to consider in the future when H-1B filings will open up again on April 1st, 2018. It's not, you can't change the individual status to H-1B status. They would have to leave in order to activate the H-1B status, but there may be limited options to consider depending on the facts of the individual's case. If it's someone who has been here as a child and has been in TPS for the longest time as a child, they may be able to perhaps seek some type of permanent solutions where they're not subject to the unlawful presence bars, and you may consider sponsoring them for lawful permanent resident status. So in situations where you have employees who may be subject to the potential of losing work authorization because of the end of DACA or TPS, and it's an individual that the company really wants to assist and invest in, it's maybe really smart to get individual legal consultation for that individual and work with your corporate attorney to make sure that they get the proper advice, of course, with the, with making sure that there's no conflicts and that there's consent among all the parties regarding the guidance or the legal guidance that the individual is getting, that it's not confidential to the employer. That's something to consider.
So someone else asked, beyond needing to obtain advance parole approval before travel, do we anticipate any problems with persons in H-1B status using advance parole? And I would say, this is good news. I can't think of any reason why there should be concern with doing that. And similarly, we're not seeing advance parole denials for any other reason than people departing the U.S. So, even though the application itself technically asks for the reason that the person seeking advance parole, we've never received an advance parole denial, and we don't expect people to be turned away at the border for entering an advance parole.
I agree, and USCIS did come out to clarify that after it started denying certain applications for advanced parole where the individuals departed. I think it's really prudent to maintain both status, or a valid advanced parole document and valid H-1B status if possible, more than ever.
And here's someone who was, I think, following up to what I was talking about with Indian nationals and said, what is the other type of filing for Indian nationals beyond EB-5? And that's just something to look at for an individual case. I know there was a time when some people were actually going back to EB-3 because it was not for India, for China,
which is right now,
for Chinese applicants, not for India, but it would be if someone had progressed far enough in their career that they could qualify for EB-1, extraordinary ability, or outstanding researcher or professor. Deborah wanted to.
For many businesses, we have also looked at sending them abroad if they have moved up into a managerial level or functional manager. If you're a multinational company, it's a huge advantage for your Indian H-1B employees to potentially work abroad for over 1 year, and then you can transfer them back after that 1 year in L1A status and file for them as multinational managers. You could get a green card in as quickly as 2 years versus 8 to 10. So if you have that possibility, it's definitely a way around, and then we do see more employers looking at this option for their workers.
So just to follow up on that, because Deborah and Laura does a lot of EB-1s, and I really want to have them share this with you because I know that we're getting a lot of questions from employees asking their employers to sponsor them for EB-1 petitions because they want to move from the EB-2 category or EB-3 category to the EB-1. And for example, a software engineer. Deborah or Laura, what would you say to employers when they're asked this question by employees to move them to EB-1 from EB-2 or EB-3? What are the requirements here?
Sure. Well, there are regulations that govern to qualify for exceptional ability. If you're looking in the EB-1 category, you have to documentary meet at least 3 of the 7 categories, and those could include evidence of your original accomplishments as found within your field, awards, publications, international recognition, membership in groups that require outstanding ability of the members, high pay. And so you're right, Lon, we do get lots of these requests. And to be honest, we're very creative. We like to think outside the box. We like to push the envelope to try and get the best benefit for our clients. But there are limitations to who really is considered extraordinary. And often once we go through the requirements and they explain that they have nothing, they've just been working for a company and they're good at what they do, but they have really no outside acclaim at what they do, it would be a very difficult application. But EB-1 can be used in the field of business, not just research or science.
Yeah.
And so we have done this for many high-level vice presidents or individuals who are entrepreneurial or who have designed or created something very of high-level value for the business that we can show has been patented or is generating significant income, generating other employment opportunities for U.S. workers. So there are some creative avenues. It's not necessarily going to be an easy process, but it may be worth having an evaluation to see if there's a creative approach that can be made.
So we have one last question here. I think we're running out of time, but the question is, what are the conditions to apply for a green card when you are currently under H-1B status? And the current law right now remains the same. We have not seen many changes with the Department of Labor when it comes to the filing of the Perm Labor Certification, which is the most popular process for an employer to sponsor a foreign national for the green card application. So the conditions to applying for the green card, if they're in H-1B status through the Perm Labor Certification process, remains the same, which is the test of the labor market. We have seen some changes in terms of the type of questions that we are seeing from the Department of Labor in their audit requests. And for employers who are making a commitment to sponsor their foreign national workers for a green card, I think it's really important to work with legal counsel to ensure that the requirements for the position meets your minimum requirements. I think that the Department of Labor, in line with the current administration's focus on hiring American, is to make sure that your job requirements are not overly restrictive or tailored to the foreign national, and to make sure that applicants who apply as a result of the testing of the labor market are clearly vetted, thoroughly vetted, meaning you just can't rely on the fact that their resume didn't include certain requirements that you're asking for. You should follow up with detailed conversations and vetting of the potential candidates. So it remains the same, and we're hoping we don't see any changes in the future as we've seen with H-1Bs. But it's a wait-and-see game right now because this administration has only been in place for less than a year and about 6 months, and we've seen tremendous changes.
So thank you all for attending. We hope we haven't scared you too badly and that we've given you some ideas for avoiding a horror show going forward with your staff and employees. And thank you so much.